Okay, we're going to get started. Welcome, everyone, and thank you for coming today. I know this is the last session, but bear with us. We're very excited to have guests live and via webinar from a wide array of industries. I'm Adam Spector, and this is Ben Lombard, and we are both attorneys in Reinhart's business law group, and both specializing in software and licensing, software and technology licensing, and also other general corporate matters, including mergers and acquisitions, general contracting, et cetera. So turning to today's topic, it's a very exciting time in the world of tech and software, as you may know. Businesses in all industries are now more heavily relying on software to help run their businesses. Software is becoming a much more integral component of the operation of businesses. So with that, there's been a proliferation of software licensing agreements and other types of related agreements ending up on the desks of in-house counsel and management teams of businesses. And so it's obviously a very specialized area of law, and what we're here to kind of help you do is to provide a high-level overview of some of the more common areas that we see issues arising in some of these agreements. And so we want this presentation to be informal. So if you have questions along the way, please feel free to raise your hand, interrupt us, whatever. Ben and I will be flip-flopping back and forth with respect to different issues and topics to keep you on your toes. So please, just again, let us know if you have questions. With that, I'll turn it over to Ben, who's going to get us started with some initial observations and our first tip of the day.
All right, thank you, Adam. We may be passing the clicker back and forth here. Yeah, as Adam said, we're going to be alternating back and forth. So we have basically 10 tips, 10 areas, and it's going to be 5 each. I think we did every other one, so keep us on our toes here. But I'm going to start out with some initial observations. And basically, when you get an agreement, a software agreement, another licensing technology agreement on your desk, the question is, for you, I'm sure, is how much resources should I spend on it? How much time should I spend on my own? Should I get outside counsel involved? What should I do? And you basically should start out by triaging the agreement and considering the importance, first of all, to your organization. Consider the cost. What is the spend for your company? And as importantly, how much money is involved from the perspective of the licensor, which will have an impact on how much you can negotiate it. But don't just focus on the cost. Focus on the importance to the business as well. Is this in a key area, critical area for the business? Or even if it's not a big spend, if something happens with this software license, is that going to impact your business, slow things down, hurt your ability to deal with your customers, hurt your ability to do your accounting, whatever it might be that's a critical business function. The other thing to consider is, especially for software as a service agreements or other agreements where there's a service component and there might be access to your facilities or access to your data, as again, even if it's not a big spend in terms of an agreement, does it involve access to critical or sensitive data? Because in those sorts of agreements, you should focus on things, and we'll get to in more detail, like data security and confidentiality and so forth. So again, think of the importance to your business. And the other thing to think about, obviously, is who the licensor is and will they negotiate and how much will they negotiate. And some licensors, large licensors, won't do much negotiation. But I've found that actually, to a surprising degree, licensors are willing to negotiate license agreements. You won't find out if you don't ask, but a lot of them, they want your business, and you'll be surprised. And they may complain. They may say, no one's ever marked up our agreement like this. No one's ever asked for these things before. You guys are outrageous. But guess what? At the end of the day, you might get the things you really want, especially if they're reasonable, if they're market, if there's a good basis to ask for it. So don't be afraid to negotiate if it's important to your business. And for those handful of agreements or areas that aren't negotiable, focus on risk mitigation. I still think it makes sense to go through the agreement, have a good sense of what's in there, make sure that the proper people in your organization are familiar with what's in there, because you don't want to have a breach of the agreement, you don't want to lose the right to the software, you don't want to have an infringement or breach of contract claim, and you want to make sure that if there are provisions where you can mitigate the risk, that you're focusing on that and that your IT people are focusing on that. So with that, I will jump into our first tip, our first area, which is expanding the scope of the license. And this is probably one of the richest areas of discussion here. We could probably spend a good chunk of our hour on it, but I will try to keep it brief because this is really the guts of the license. And you start by looking at the provision that is the magic words. It says the licensor hereby grants the right to you to use the license. And an overall theme here, when you think about the scope of the license and restrictions, is to make sure as much as possible that the grant of the license is clean and that there aren't unnecessary conditions or restrictions. One of the things you want to avoid is a situation where you have not only a dispute that's a potential breach of contract claim, but you have a potential copyrights or other infringement claim, because an infringement claim is going to give the licensor additional remedies, potentially additional rights. So the more you can make the grant of the license clean and have any limits, things you can live within, the less of a chance that you're going to have a potential infringement claim. I'm just going to cover a series of items to think about in this area. A couple of definitional matters. Consider who the licensee is in the defined terms. And in particular, think about your organization and whether you need to include subsidiaries, affiliates, or other related parties who should be as part of the licensee. Because that's typically the way we'll address that question. If you have a parent organization that's the licensor, but you have subsidiaries and other facilities that are going to be using it, you need to make sure you're covering each entity in the definition of the licensee or in the license grant language. Definition of licensed software. Make sure the licensed software is defined to refer to the product with enough clarity and specificity so that it's clear what's being licensed. And also make sure that the definition of licensed software includes updates, upgrades, other things that you may have a right to receive under the support or other provisions of the agreement. I mean, typically, licensors will create a division at some point between what they might call new releases, things that are marketed to the market generally as a whole new version, versus upgrades, fixes that you have a right to receive. And you need to make sure your licensed software picks up the things you have a right to receive without paying more for it. A few other things. Restrictions on use. Watch out for sort of general terms that may be hard to understand or ambiguous on restrictions of use, like a lot of license agreements say for only internal business use. And that, I'm not quite sure what that means. I always try to strike it. Does it mean you can't use the software in connection with providing services to customers or providing products to customers? It's unnecessary because typically a license will have a series of things you can't do that are much more clear. If you strike the internal business use restriction and just focus on what you can't do, that should get the licensor what it needs. And the sorts of things you might see in terms of restrictions on use are things like prohibitions on modifying the software, reverse engineering, selling the software, things you could probably live with because they're specific you can comply with, rather than more general language that sort of isn't flexible enough for how you need to use the software. Other issues, copying. Look for language in terms of how you can copy the software, and make sure you understand from your IT people how you're actually going to use it. A lot of licenses prohibit copies or say you can only have one version, which may work for some environments, may not work for others. Understand whether you're going to have backup copies or need backup copies. All these things are generally negotiable as long as you understand what you need. Look at limits as to where the software can be located. Some agreements may say that you can only locate it on a single computer. Does that work for your organization? May that change in the future? Some agreements may say you can only use it in connection with certain operating systems or hardware platforms. Again, make sure it works now, but more importantly, make sure it's flexible enough for the future. Make sure you have access for consultants and contractors. That is necessary for a lot of businesses. If the agreement doesn't say that, and yet you provide access to consultants or contractors, you may be in breach of the scope of the license and be facing a breach of contract claim or an infringement claim. A lot of firms have, in their IT departments, use contractors or consultants to help them, and you probably need to give them access to your software. And if you can't do that in your license agreements, you may have an issue. focus on geographic limits. Some software agreements put provisions in there saying you can only use it at a particular facility, or maybe you can only use it in the U.S. And maybe the licensor has reasons for that, but you need to flag those issues and discuss it with the licensor if that's important to your business. And some of these things, again, reduce your future flexibility. If you're only going to put it into one facility, but in the future you may expand, are you going to remember to look back at your license agreement? And if you do have to look back at your license agreement, what's the licensor going to ask for if you have to go back to the licensor? I think the last thing that I want to cover is limits on the numbers of users or seat limits or similar restrictions. And typically you'll see these in connection with licenses that are priced based on number of users, not always, but typically. And first of all, you need to be careful about how that reads and that you're going to comply. For example, if you have, you're anticipating installing the software on 10 desktops and it says 10 users, make sure there's only going to be 10 users and that people won't be sharing the desktops and violating the restriction. So make sure you have accurate count of who's going to be using it and for what, and that it has room to expand. And the other thing is try to get in language that says that if you exceed the use restriction, that it's not a breach of the agreement, and that the only remedy of the licensor is to increase the fees based on the then current per user fee. Because again, avoid a situation where there's a breach of contract or an infringement claim based on forgetting to update the number of users if you need to. So with that, I'll turn it to Adam for the next tip.
Thank you, Ben. So the next tip is testing and acceptance. And before I get into that, one thing we forgot to mention, as you've probably picked up on it already, is that given our audience base, we've catered this presentation to negotiating these agreements from the licensee's perspective. The vast majority of our audience is kind of non-software providers. So moving on to tip number 2, testing and acceptance. The concept is just as it sounds. It gives the licensee the opportunity to test the software and formally accept it prior to a software license agreement being formalized or being obligated to continue to use the software for the term of the agreement. This concept is especially important when dealing with custom software. As it implies, a custom software is something that is made just for you. So given the specifics that you're asking for and probably the large amount of money that you're paying for it, the licensee wants to make sure that the software is what it is paying for and it's going to work in the way that it wants it to work prior to being obligated to use it going forward. Obviously, that's easier said than done. But part of the negotiation of the contract is laying out and setting forth the specifications and the parameters by which the licensee expects the software to work. On the flip side, that also helps the software provider or the licensor in developing the software for the licensee. So it kind of brings this testing and acceptance process brings everyone to the same page, which it actually turns out to be pretty useful to both parties. So again, the agreement should list the specifications to which the software must conform. And if the software doesn't conform, the licensee can have some sort of remedy. So again, the agreement should specify what that is. Should the licensor be obligated to fix and continue to improve the software, or can the licensee just say, you know what, this doesn't work for us, see you later, we're done. Some licensees, depending on their leverage and negotiating capabilities, are able to negotiate an acceptance based on licensee's discretion. It's less rare than setting forth the specifications and parameters in the agreement, but if a licensee has that ability, it's obviously a much more beneficial term to the licensee to be able to get out just based on whatever they're feeling at that time. Another concept that we see a lot in testing and acceptance provisions is deemed acceptance. We tend, as a best practice, to avoid that type of provision and modify it. What that really is generally after a certain number of days, if licensor hasn't heard either yes or no from licensee, they deem the software to be accepted and the agreement to be in full force. This leads to potential questions and ambiguities, which is why we tend to avoid it. A lot of times there's a deemed, quote, deemed acceptance, but when did the acceptance occur? Did it really occur? So we tend to avoid that. As just a, again, another best practice, and this is fairly obvious, but if you're going to enter into a license agreement that has this testing and acceptance procedure, probably best not to pay everything up front prior to acceptance. Leads to issues with respect to getting your money back if you decide not to accept, and also it could, leaving some of the money on the table, or I guess withholding some of the money up front helps provide a better, helps make the licensor give you a better product in the end. So as Ben kind of alluded to earlier, finally, another best practice in this respect is to require new releases and enhancements to the software. They have to go through that same testing and acceptance procedure. That slips through the cracks quite a bit, and it's generally never in a licensor's first draft. But enhancements and new releases and upgrades can all be just as influential as the core software and important as the core software. So it's important to make sure that that is acceptable to the licensee just as the core software is. Moving on to our tip number 3 to Ben.
All right, I'm back. Thank you, Adam. Tip 3, indemnification and limitation of liability. Any software license, really any agreement that involves the access of the sort of intellectual property should have an infringement indemnity. I don't think we see a lot of agreements without it, so mostly it's a matter of negotiating the scope of it. And from the licensee's perspective, you want to make sure the language is broad enough to fit your needs. For example, it's generally in the licensee's interest to have a broad definition of intellectual property. Some first drafts from licensors might limit it to, say, just copyright infringement, whereas software can involve a number of different types of intellectual property. And from the perspective of the licensee, what's key is that someone's suing them for infringement, and it should be the risk of the licensor, presumably from the licensee's perspective, to handle the defense and any damages related to an infringement claim. And infringement indemnity is focused on third-party claims. Generally, it does not cover losses to the licensee relating to loss of business, loss of the software. It's generally based on, you'll step in and protect me if someone sues me because I'm using your product and they're claiming it's infringing. The other thing to look for in terms of the broad definition is make sure that the definition of indemnities covers who it should. Typically, you want to see it cover more than just the licensee, to include related parties, employees, others who potentially are using the software and in theory infringing by using it. In the indemnity language, it's pretty common to see a remedies provision as well. Typically, what this deals with is a situation where there is a final determination, an injunction, a finding. Sometimes it's just based on the licensor's belief or reasonable belief that there's going to be an injunction or a finding of infringement, and it details basically what happens in that situation. Usually the way it works is it's a series of alternative steps, maybe sequential steps. For example, it could say that the licensor would attempt to secure a license from the party claiming infringement. Typically, there'll be a provision saying that the licensor can modify or replace the software with non-infringing software. And from the perspective of the licensee, you want to include some language that provides that basically that replacement or modified software will have substantially the same or fully the same functionality and features. You don't want to get an inferior product because of their workaround of an infringement claim. Eventually, if you go down the line, usually from the licensee's perspective as a last resort, you might allow the licensor to terminate the license. If you've paid fees, like if the license is structured where there's a significant upfront payments for fees, you want to make sure you get a refund of those fees, and typically those provisions will provide for a refund. It's pretty common to see it done sort of prorated over some sort of life of the license idea, maybe 5 years, whatever makes sense, and you should make sure that what is in the licensor's draft makes sense. But the idea is that if an infringement claim comes after 3 years, you've had 3 years of use of the software, so you should get all your fees back. So that's pretty typical. You should make sure that the remedies provisions, just make absolutely clear that they do not override the duty to defend and pay damages. Sometimes there's exclusive remedy language that's a little bit loose in these sections. You just want to make sure that you're not undercutting your indemnity by the remedies provision. The other instances where you might see indemnification, less common, but is if there's a large service component to what you're getting. You might want to cover other sorts of third-party claims based on having service providers at your facility. You might try to cover indemnity for their work products of the services that are being provided. So you can try some expanded indemnity language in those situations. Depending on the circumstances and the licensor, you can have success in that area. The next provision that I think you'll see in virtually every license agreement, software license agreement of any type, is a limit on damages. Typically, there are 2 types. There's a cap on the dollar amount of the damages, and then there is some sort of elimination of consequential damages, indirect, incidental, punitive, the whole litany. If you're in certain circumstances where you have enough leverage, you could try to eliminate that significantly or work around it. But more often than not, what you're doing is you're trying to negotiate sort of in a reasonable and appropriate scope for those limits. For example, the cap, cap is pretty typical. Usually it relates to the amount of fees in some sense. You just want to make sure that that cap makes sense for you. A pretty common formulation is that it's up to 12 months, like the trailing 12 months of fees paid. Does that make sense for your fee structure? Are you paying a big upfront fee, and 2 years down the road, it'll be more than 12 months, and that number doesn't make sense anymore? Or on the flip side, if you're paying it over time and you have an issue in year 1, have you not paid enough fees to really have a meaningful remedy in the first year when a lot of issues can arise? So sometimes you can work around that. You can say fees paid or payable. You could put in a number in the alternative, so you could say it's the greater of $X or fees of some sort. So those are some things to work around that. And sometimes you can get a multiple of damages, at least in certain areas that are significant, or multiple fees rather. So for example, confidentiality, oftentimes we try to get confidentiality obligations excluded from damage limits, but not uncommon compromise to say, okay, it's subject to a cap, but it's a different cap. It's a much bigger cap, if that makes sense. Yes, question?
Are you ever successful getting a high dollar amount? There's no relation to the damage that you cause. You ever try for a fixed dollar amount?
Yeah, I mean, that's an example of, I'm sorry, I think I'm being signaled to repeat the question, because of course we do have webinar viewers, I apologize. And the question is whether we've had success in a high, just inserting a high dollar amount for damages rather than something relating to fees. And obviously that may be in the licensee's interest. The issue is going to be from the licensor's perspective. They make their money on their fees. So if they start accepting too many license agreements with damages that don't relate to fees, that can endanger their business model. Yeah, I would say it's a question of leverage. I mean, I think we have seen various workarounds on damage limits, including that, but it's pretty rare that you would just get a generic any claim whatsoever is going to be subject to a high dollar amount. I think where we've had success, as indicated, is if there's discrete areas that you care about or where you see risk that the licensor can get comfortable with. If it's confidentiality or data security is really important, or some other thing is really important to you, you might have a special cap for that. But to say that any claim whatsoever is subject to a real high dollar amount is not going to be palatable to a lot of licensors. Indemnity, the infringement indemnity should be carved out of any damage limits because that is a third-party claim that is really intrinsic to what the licensor is bringing, that their software doesn't infringe. So usually it's not an issue to get it excluded. I also try to get it excluded from the consequential damage limits as well, or at least put in language clarifying that if a third party is claiming consequential type damages due to infringement, that that's deemed to be direct damages for purposes of the license agreement, that there's no opening for the licensor to argue, oh, that's covered by the carve-out because the claim is based on consequential damages. And with that, I will turn it back to Adam for the next slide.
Thank you. Kind of reminds me of a wedding speech where little kids are giving a speech and they go word by word and kind of down the line, but it's hopefully a little better than that. The next tip, or tip number 4, relates to an insurance requirement of the licensor. And so, as you know, insurance is a key component to the risk allocation in a software license or a similar type of related agreement like a services agreement. It's especially important if services are being provided by a vendor on the licensee's premises. Less important, of course, if in a traditional straight software license. Insurance ensures that someone, i.e. the insurer, will have the resources to be able to pay on a claim that's made for damages that are incurred in the event they do occur, compared to indemnification, which Ben was just talking about, which merely shifts the risk between the parties and doesn't ensure that the party indemnifying has the actual ability or resources to make those indemnification payments. So some of the common types of insurance that licensees require of licensors are general public liability insurance, automobile liability insurance, workers' comp, which relates obviously to work-related injuries to licensors, employees while performing jobs, umbrella or excess liability insurance, professional liability insurance or E&O insurance. So those are kind of obviously very standard types of insurance that are required in contracts across the board, not just software licenses or services agreements. But now what we're seeing, given the boom in big data and the importance of data as a component of a lot of software, is cyber liability insurance, which should cover data breaches. And data breaches are generally not covered by professional liability insurance or E&O without some sort of additional coverage in that regard. So that's why cyber liability insurance is becoming more of a question and an issue. We haven't seen licensors agree to it as much, but I think in time it's going to become more of a standard requirement. An additional component of the insurance requirement is that the licensee should request that it be added as an additional insured on each of these policies to the extent possible. This allows the policy to protect the licensee in the event licensee is sued based on licensor's actions. So the last component of insurance, but certainly not the least, is to try and obtain a waiver of subrogation from the insurance carrier. This prohibits the insurance company from being able to sue licensee, i.e. a third party, for stepping into using its right of subrogation to sue a third party after a claim is made on the policy by licensor, the insured. It essentially will help protect the licensee's indemnification rights and ability to obtain payment on damages it incurs. So that's it on insurance. Moving on.
Right, confidentiality is next. Now obviously, the importance of confidentiality will vary by the agreement. This is another area that's probably most significant if either you'll have service providers on your premises or as part of installation or the process they'll have access to your system, or potentially if you have a software as a service sort of arrangement where your data will actually be with the provider, the vendor. So it can vary in importance, but where there is access to the licensee's confidential information, it becomes a key provision. A lot of times, if there is some initial processes with the licensor, whereby they're scoping out the project, you're providing them information in order to set the terms, especially if it's a bigger project, you'll want to enter it to an NDA up front so that you have a form of confidentiality agreement you're comfortable with before you start giving them any sensitive information as part of the process. And that's definitely good practice, and we obviously need to be cognizant of that when we're reviewing the license agreement to make sure we're not superseding that previous NDA if we want it to stay in effect. And so what we'll typically try to do, if we're aware of it, is reference the NDA in the license agreement, state that it remains in effect, and that will generally be the confidentiality provision of the license agreement, just referencing the earlier NDA. If not, if the license agreement is the first place or the final place to deal with ongoing confidentiality, then you review the confidentiality provision of the license agreement. And generally, you look at a lot of the same sorts of things you'd look at in any NDA. You want to make sure that confidential information is broadly defined from the licensee's perspective. I generally don't like marking requirements because they're probably often not followed. So unless you have real strong processes in place to mark each tangible piece of confidential information as confidential, you want to avoid that. In fact, I like to try to define confidential information as including any information provided by or on behalf of the licensee or to which the licensor or any of its representatives have access to, in whatever form, and then rely on customary exclusions to deal with situations like, rather than saying it's confidential information, it's proprietary information, just say it's any information, and then have an customary exclusion saying it doesn't include information in the public domain, as of the time of release, or information that later goes into the public domain, not at the fault of the disclosing party, so that you have, good, clean exceptions, and it's clear what it means when you say confidential information. Another thing to be aware of in terms of confidential information is the term of it. Again, it depends on what they have access to, but obviously, if you have real sensitive information, you want to try to keep the term as long as possible, and especially if there'll be any access to trade secret information, make sure that the confidentiality agreement isn't going to undercut your trade secret protection, so that the trade secrets remain confidential or subject to the confidentiality for as long as they remain trade secrets, which in theory could be perpetual. Just a note here to consider special industry concerns. If you're in healthcare, you provide services in the healthcare area, make sure that you're cognizant of HIPAA. If there's going to be any access to protected health information, you probably need to have the vendor sign what's called a business associate agreement, or BAA. Similarly, in the banking area, we usually put in special provisions relating to non-public personal information, or NPI, if there's any access to that. So if the vendor's coming in and will have access to bank customer account information, or they'll come in and they'll have access in a healthcare industry to patient information, you need to make sure that they're properly tied up so you're complying with your legal responsibilities. Briefly, a couple other provisions that sort of relate to confidentiality, although are often in other sections of the agreement. It's not uncommon, especially if you're in a software as a service or cloud environment, to have a data aggregation provision. What this basically means is that the provider will want, the vendor will want the right to use aggregated data of the customers. Some clients, as a matter of principle, like to try to strike those because they believe we own our data. We don't want anyone else using it without our permission. Usually the vendors fight that hard because part of their business model is learning things from aggregated data. So what we'll try to do is we'll try to work with the provision and make sure that it's crystal clear that it's protecting the anonymity of the data, of who the licensee is, that there's nothing identifying the licensee whatsoever. We'll also try to put in language that says the licensee has no responsibility whatsoever for the aggregated data. You know, we're not going to be obligated or liable to you if somehow our data is wrong or isn't meeting your needs. Another provision sort of related to confidentiality is right of publicity. The question here is whether or not the licensor has the right to use the licensee's name in its promotional materials. Obviously, a lot of licensors like to do that, and some companies don't feel comfortable, at least without their consent, associating their name with a product. If there's a provision that's a right of use provision and the licensee client wants to, we'll try to change that. If there's no provision, a lot of times I'll try to drop in a provision saying you need our consent to use our name, if that's what the client wants. You know, there's a wide degree of sensitivity to that issue. But I tell you, if you're not happy with the product, even if there's not necessarily a breach, you may not want your name associated with the product in the licensor's advertising. And I think that takes us to tip 6.
So tip number 6, data security and disaster recovery. Related in a way to confidentiality is making sure that all the data provided by a licensee to licensor via the software remains secure and protected. We'll discuss cloud computing arrangements in a little bit, but data security and disaster recovery become even more important in those arrangements. Something that is becoming increasingly common for licensees is to request a security audit, essentially, of the policies and procedures of licensor. So licensees want the ability to go in and not only to read what their, the document that describes their data security and disaster recovery policies and procedures, but to actually go in and audit the site, make sure that the server rooms are secure, locked, have a security guard, fireproof, whatever it might be, and also to go into the systems of the licensor, conduct penetration testing, to be able to figure out where are there holes in their system that hackers can get into? Where are they? How can this be improved? And make a determination at that point as to whether the licensor systems are secure enough for the type of information that licensee will be providing. Given that all the data that licensee provides is held on third-party servers, especially in the cloud computing context, end users should require certain items relating to this data security and disaster recovery. Some of these are redundant hosting, disaster recovery, and business continuity policies and procedures set up, data backup practices and policies, frequent backups. That being said, we always advise as best practice that licensees have their own data backup procedures in place rather than relying on other third parties or the licensor. Obviously, easier said than done, but as a best practice, that's what we see. Let's see if there's anything else. I think that's it on data security. Tip number 7.
So availability and performance service levels. Typically, there's 2 main environments where this is most significant. One is the software as a service or cloud environment, where data is actually being housed and accessed through a web environment offsite. And then second of all is the issue of support arrangements and what is the performance service level for providing support if there's issues with software that's actually being housed on your own servers. So covering the first issue, which is the idea of access to data if it's off-site, two typical things you're thinking about. One is just basic availability. Is the site down or not? Can you reach it at all? And then the second issue is response time. Can you reach it, but is it really slow? So slow that it's impeding your ability to work. On the first issue, and by the way, a lot of these arrangements are in like an addendum or an agreement that's called a service level agreement, SLA. And typically what it will provide for availability is some sort of percentage, usually in excess of 99%, 99.5 to 99.9999 is some range of industry standard. It's usually measured for all time, 24/7, 365, so that at any time you want to access it, the question is whether you can access it or not in terms of availability. And usually what the agreement will provide is if it falls under the standard, there'll be a remedy, some sort of offset of the fees. Typically it can be escalating based on how many times it falls under. There's also some standard exceptions, things like scheduled downtime, things like your own internet connectivity issues. Obviously if your system's down and you can't access, that's not the vendor's issue. And the exceptions are something to review carefully because some of them make sense and some of them are pretty broad, and the question is whether that works in terms of your expectations of access. In terms of response time, it's usually measured based on time, no surprise. Oftentimes it's measured as some sort of deviance from an index. Like there's a Keynote Business 40 Internet Index that will have like 40 of the biggest sites and measure their response time, and basically you'll get something from your vendor saying it'll be within a second, a half second, whatever it might be, of this index. Sometimes it's also just a set period, and usually what it's measuring is the ability over some average download time, so that that there should also be a mechanism to be able to police this, or an understanding with your IT how you're going to understand if you're policing it. But the idea is that you're measuring the average download time as people are using the site to access data, and then comparing that to either an absolute number or an index from the largest websites to see how you're doing. And again, if you fall off of that, you should get some sort of remedy in terms of fee abatement. And if there's severe and persistent problems, a lot of times agreements will provide termination rights, so you can get out of the agreement and you're not locked in if it's a longer term agreement. With respect to the support response times, usually that will be and also a separate addendum on maintenance and support, and that's some version of this of a way to measure the severity of the problem and the response time. So there'll be like critical issues. The system's not working at all, response time of an hour or two or less, all the way down to minor issues. We're just not happy with something, response time of a day or two or longer. And usually you won't get a guarantee of a solution. The guarantee of a solution to issues are usually addressed in things like your warranty and your acceptance process. Down the road, if you have issues, typically it's some sort of you're paying for support, so it's some sort of standard to use reasonable efforts to get back to you in a period of time to provide an answer. Maybe the answer is there is no answer in a period of time, but it's at least some guarantee that if you're paying for support, you're going to actually be able to reach someone who's actually going to be working with you to solve a problem within a time that relates to the severity of the issue. And I think I had in my notes data return, but I think Adam's probably going to cover that in termination, because that's another software as a service issue where you have data offsite and you get to termination. How can I get my data back, and what rights should I have? So I'll let Adam cover that in the next tip on termination.
All right, so termination. When determining what term of an agreement, what term the agreement should have and what termination rights either party should have, it's important to put into context what especially from a license fees perspective, what you're using the software for, how integral it is to the business, and what you're paying for it. It's going to help determine, well, do we want to be able to get out of this tomorrow if need be, or can we let the agreement ride out for the rest of the year even if we don't want to keep using it. Generally, for a software component that's integral to the business and that a licensee is paying a lot of money for, the licensee is going to want the flexibility to get out in a moment's notice or at a certain amount of days' notice. This is also known as termination for convenience. Many times, the agreements do not come from the licensor with that provision in it, but ultimately, after negotiation, there are generally compromises to be able to get that type of provision in. What the agreements do come from the licensor looking like is containing evergreen provisions or these automatic renewal provisions, which we try to avoid most of the time. And frankly, licensees do not like to have those types of provisions in their agreements. Because these are provisions that make the agreement automatically renew if the licensee does not provide notice within some certain time frame. And if licensees are like humans, they forget a lot of times and don't have the best method to keep track of when to give certain notices, and they may have a lot of agreements that all have different notice periods at different times that notice has to be given. So things slip through the cracks, and then all of a sudden the licensee finds itself in an agreement for another 1, 2, 3, or 5 years, and it didn't really want to be, and with no other way to get out other than potentially maybe a material breach of the agreement by a licensor, which may or may not happen. So as a best practice, we like to modify these provisions and to permit renewal terms. We think that's great, but at the affirmative election of the licensee, as opposed to an automatic renewal with the licensee saying, hey, we don't want to be in it. Issues arise when a licensee pays up front for its license, but decides later to terminate. And by the way, let me take one step back. If you're able to negotiate a termination for convenience provision in an agreement with the evergreen, they kind of counteract each other. And so either there's some sort of ambiguity there, which you probably want to avoid, but also there's an argument that says, hey, even though this automatically renews, I can get out. See provision that says termination for convenience. So another issue that we look for in termination provisions is relating to upfront payments versus payment over the course of the term, especially when there's a perpetual license involved. So there was an agreement that the licensee would be able to use the license of the software in perpetuity. And so what happens if you've upfront and all of a sudden you don't want to use this, or you don't want to use the software? Do you get any money back? You've only used it for 6 months, but you could have used it for 100 years. So there's certain ambiguities there that we like to try and avoid if possible. Something we're seeing more often now, especially in the software as a service and data hosting context, is a provision for return of data upon termination, as Ben was alluding to. And this is oftentimes an area that requires some negotiation and compromise, because licensors generally will request a fee for license for the return of data, and that a lot of times does not sit well with licensees. Like, it's my data. Why can't you just send it back to me? Give it back to me. We own it. It's mine. It just happened to be submitted through your software or you're hosting it. And so what you really have to do, or licensees really have to do in this context, is weigh how important the data is to the company, how quickly the company needs it back, and a lot of times this has to deal with the transition period from software A to software B, and whether you have a backup of it, or that kind of stuff. So a lot of times the compromise ends up being, okay, we'll pay you for it, X amount, but we need it within 5 days after termination, and we need it in this format. So something to consider there. Last 2 tips. Here's tip number 9 from Ben.
Okay, so we're on the home stretch. And just to add to something that Adam was talking about, another compromise you can see on data return is a fault-based payment system too, so that if you're terminating due to the vendor's breach, they pay for data return basically, and if it's your breach, you pay, or some sort of variation on that. So force majeure is topic 9, and obviously you see force majeure in a lot of different commercial contracts. They tend to show up in software-related contracts, typically where there's a significant service component. It's usually not much of an issue if the software is just installed, but most software contracts do have a service component because you usually pay for support too, which is a service component. And then obviously if you have software as a service or off-site hosting of some sort, that essentially is a service with force majeure provisions as well. So force majeure is, hopefully, I think our audience is our lawyers, you know what force majeure is. It's inability to perform as a result of unforeseen events. You want to make sure that this definition is nice and tight, and that whoever's arguing force majeure is taking reasonable efforts to fix the force majeure issue. Sometimes, if there's a long-lasting force majeure, you might want, suspension of fees, some sort of fee abatement. You might want the right to terminate at some point. And then the other thing in connection with force majeure is you want to see, if possible, if you're in the software as a service environment, if you could possibly carve out, or even the support environment, if you can carve out the sort of, I think it's more the software as a service actually, carve out the SLA obligations. The idea, at least from the licensee's perspective, is that the licensor is telling you what great data protection they have and redundancy and all these different great things that you're paying them all this money for. In those situations, I'll try to argue that you don't want the licensor to then come back and say, but we have the right, if some sort of force majeure event happens, like a fire in the facility, to not be subject to our service, our availability obligations, or whatever it might be, because your response should be, no, you're telling us that it's secure, that you have redundant facilities, that we're not going to be subject to an issue like that. And depending on the circumstances, we've had some success in that. That's an area that can be hotly contested because a lot of these providers don't want to see creep in terms of their obligations, and if they normally don't have to deal with having a force majeure exception not apply, they don't want it to apply to you. But the logic can be strong on the licensee's side if you have the leverage in a particular situation. And I think we're doing well on time, and we've got probably one of the most interesting topics saved for last, cloud computing.
All right, so we've made references to cloud computing or SaaS agreements, software as a service, throughout the session here. And if you're not familiar, everyone's kind of heard of the cloud. Amazon has their cloud, and everyone is kind of storing things in the cloud. But what is that really? And it's really remote servers hosted over the internet to store, manage, and process data is the long and short of it. And cloud computing is one of the fastest growing areas right now in the technology and information technology space. Software as a service agreements, as a result, are becoming much more popular. This is a model where software applications are being provided over the internet, as opposed to a direct license of software from licensor to licensee. And through these types of arrangements, the end user, who we've been calling licensee, does not purchase a copy of the software. So really, it's a service being provided to an end user. Certain risks are of greater concern than they are even in a traditional license space, including confidentiality, data security, data privacy, which we kind of alluded to earlier. Confidentiality, if you think about it, data is now being provided over the internet, where hackers and other third-party malfeasors are looking to steal data all the time. So it's important that data is sent in a safe and secure method, both from the end user's perspective and also from the cloud services provider's perspective, whether that be encryption or some other type of secure method. There also need to be, require software as a service providers to handle the data in a confidential manner. And this requires much greater detail negotiation in an NDA or in a confidentiality provision than potentially what you would see in other types of agreements. Data security, there are public clouds and private clouds. And public clouds are where multiple different end users' data are aggregated in the same cloud, whereas private cloud, you kind of have your own offsite storage server through the internet, but it's private to just one end user. So when you're in a public cloud, you kind of want to make sure that data isn't going to overlap or kind of seep out into someone else's area, and so that no one else has access to your confidential information. Service level arrangements or agreements, which Ben discussed earlier, are also very, very important in this context because it is all over the internet, as Ben was talking about. Got to make sure that the service level agreement spells out exactly what you as an end user or licensee are expecting, and make sure that appropriate penalties and credits are provided for failure to uphold to those service level agreements. I think finally, in this context, it's, again, kind of like Ben talked about at the outset of the session with his initial observations, SaaS agreements and cloud computing agreements are very widely with respect to how negotiable they are, depending on who the provider is, the leverage that the end user has, and the type of service being provided, whether it's standard or customized. Obviously, in a standard type of agreement, much less likely in this context to be negotiable, as opposed to a customized agreement or customized service, rather, that's being provided by a cloud service provider. So with that, that's kind of the top 10 tips of issues that we see when negotiating software license agreements. We hope it was helpful for you to at least start spotting issues and raising questions to licensors, or at the very least say, hey, I remember Adam and Ben talking about this. Maybe I should give them a call to discuss it further. So with that, anyone have any questions? We have a few minutes left. Do our web viewers have any questions? Maybe they do, actually.
First. Sure. All right. Question. What is source code escrow and when is it used? So some of you may have heard of source code escrow. You may wonder what the heck it is. Some of you may be more knowledgeable. Source code escrow is generally used when you have a licensor that you may have some doubts about for whatever reason, and it's a critical piece of software that's being licensed. So you want to know if something happens to that licensor that you'll be able to still use the product. So typically what a source code escrow does, just as the name indicates, is you get a third party, and there's a number of commercial providers, to take possession of the source code and hold it in escrow for you. And then on certain triggering events, it will be released to the licensee. Things like the bankruptcy or insolvency of the licensor. Maybe there's other sorts of material breach events. In any event, certain things trigger it, and then upon release, you as the licensee have access to the source code, which means in theory you can continue using the software. So that's the theory of source code. How helpful is it really depends. Issues that tend to come up involve, is anyone paying attention to what's in escrow and making sure it's up to date? If you enter into an agreement and you've had a series of new upgrades and releases and modifications over the ensuing years, but no one's done anything to the source code escrow, you might have something released to you that's pretty useless. By the same token, if you do have a release of source code, are you going to be able to do something with it? Do you have either the in-house capability